She begged for another chance. But the judge had one question that changed everything. By the end of this hearing, Molly White would learn that addiction doesn't erase responsibility, and the sentence stunned the courtroom.
Please.
Thank you very much, Your Honor. Attorney Robert Ration, the Assistant Prosecutor from Sauk County.
Thank you.
Good morning, Mayor. Please, Courtroom Johnson on behalf of Ms. Molly White, who's in custody.
All right, she should be here in just a moment. Also here before the court today is Mr. Luke Whitback. He's the agent from the Michigan Department of Corrections who is serving as the probation officer on this file today, as he is the author of the pre-sentence investigation reports in each of the two cases. Miss White, again, is in pretrial custody or post-conviction custody, whatever, and she's being brought over here in just a minute. All right, Miss White has been escorted in, is now seated at the defense table next to Mr. Johnson. We're here today for sentencing on these two cases. File number 3614 is for possession of the controlled substance methamphetamine as a fourth habitual felony offender based upon a jury trial conviction on November 19th of 2025. File number 3619 is also here for sentencing. And in that particular case, there were convictions at a trial. That trial was held on June 3rd of this year, and there are four offenses. One, for tampering with evidence. Second, for a assault resist obstructive police officer. A charge of delivery of the controlled substance methamphetamine and bringing contraband into a jail. All have a fourth habitual felony enhancement potential. All right, let's take a look here. Mr. Ringstrom, any objections to PSI in the older file 3614?
No, Your Honor.
Mr. Johnson?
No, Your Honor.
All right. Mr. Ringstrom, now looking at 3619, any amendments, corrections, or objections to make to any of the contents contained therein?
No, Your Honor.
Mr. Johnson?
Yes, Your Honor.
All right, let's go. What we got?
Beginning with the charge of tampering with evidence, OB 14 is scored at 10 points for being the leader of a multi-offender situation. I believe that sentencing offense just had one offender, my client, Your Honor. We believe that should be scored at 0.
Okay.
Court heard the testimony that she flushed alleged narcotics down on the toilet. She was the only person that did that.
I agree.
Thanks, sir.
We're going to change that scoring for that count one, tampering with evidence. We're going to score OB 14 from 10 down to 0. That changes the OB level from 35 to 25. Before I go over any adjustments to the guidelines, Mr. Johnson, any further corrections on that guideline scoring?
Yes, Your Honor. Also on that offense, OB 19 is scored at 25 points for threatening the security of the administration. Court heard the trial. No force was used here. I don't see how destroying something that wasn't supposed to be in the jail in the first place threatened the security of the penal institution. She did exactly what law enforcement would have done if they had collected it, got it out of here.
Hold on. Mr. Ringstrom?
Well, Your Honor, certainly something was flushed, obviously. What I believe was it was flushed. Nobody at that time knew what was being flushed down the toilet. Nobody knew anything. All of this stuff, for all we knew, it could have been a bomb. I don't know. I'm just saying that realistically, her actions did, while being incarcerated, while doing what she did affect the jail at that time. And jail had to shut down. Jail had to do lots of searches and everything as a result of that. So.
The court in part will grant the objection. I'm going to reduce OB 19, which is currently scored at 25 points, to 10 points. I believe that it interferes with the administration of justice, but I think the flushing it did not necessarily threaten the security of the institution. So the court again reduces that by 15 points. We're now down to 10 points for OV 19, and that's going to take us to a total of 10 points. And that should have an impact on the guidelines. So let me take a quick look. This is on the F grid, so it may, yeah, it does. All right, so, and it does. We are now down to OV level 2, and that takes us to 12 to 20, or actually 48, 12 to 48 if there's a fourth tab within the discretion of the court. All right, Mr. Johnson.
Yeah, on the police officer assaulting his obstructing charge.
Yep.
Only offense variable scored is OB 19.
Mm-hmm.
And it's essentially the same argument that this was not a physical resisting. The testimony was she was told not to flush the toilet.
Hold on. I'm sorry. I didn't mean to stop your thunder. I guess I did mean to. Mr. Ringstrom, I'm likely to score it down to 10 points again.
People would be making the same argument too, so.
I'll go ahead and amend that scoring of OB 19 from 25 to 10 points. That gives us a total OV of 10 points, and that is on a Class G grid. It doesn't have too many choices, so it's probably, oh, it does. It changes it just a bit. So it changes it from a 7 to 46. Well, it doesn't much, but 5 to 46. I still think that's a good objection. Thank you. Anything else, Mr. Johnson?
Yes, Your Honor.
Okay.
And it's the same argument, yeah, on the delivery, manufacture of methamphetamine charge.
Mm-hmm.
OV 14 is scored as being a leader in a multi-offender situation. The sentencing offense here is delivery. She was the only person accused or convicted of delivery. Now, there were some accusations that other people may have possessed, but that's a different charge. And so we don't think that OV 14 should be scored at 10 points.
Mr. Ringstrom?
I absolutely disagree with that, Your Honor. In order to be able to have a delivery, you have to have a recipient also. There was two people that were definitely involved. She obviously was the leader in that situation because she was the one who wound up doing the actual delivering as well.
All right, thank you. One moment. Seems like I remember seeing a reference in the bench book. One moment. Yeah, this is what I recall. The court denies that challenge as to offense variable 14. The court specifically does based upon the case of People versus Dickinson, Dickinson. That was a Michigan Court of Appeals decision, 321 Mich. at page 1, and specifically at page 23. This was a 2017 decision. And because it has, the defendant takes it from one person, brings it into the jail and transfers it to another person, it allows the court to score it as a leader. Therefore, the court denies that challenge. Mr. Johnson, next.
Your Honor, we'd also be challenging offense variable 25 on that.
Oh, you mean 19?
As he has 19 to 25 points. And we will be relying essentially on People v. Dickens, 509 Mich. 170, 2022 case. People v. Hines, docket number 363151, 2025 case, in which they talk about hypothetical threats not being enough to score 25 points for the threatening the security of a penal institution. Now, the Dixon case did involve a cell phone and required the court to find how the cell phone or use of the cell phone actually threatened a penal institution. Here, My client was convicted of having something in the jail that wasn't supposed to be there and, delivering to another person. But no one was injured. No fights broke out. No emergency response needs to come for any overdose. It was very, was believed to be a small amount, a point of methamphetamine, Your Honor. So although, she did have something, was convicted of having something in the jail that she was not supposed to have, we don't think that it created a threat to the safety of the penal institution.
Thank you. Mr. Ringstrom.
She brought meth into the jail. She delivered that meth. I don't think there's any hypothetical threat here at this point in time. Clearly, having drugs in the jail can be a threat to the penal institution. They had to wind up shutting down jail, basically doing search of everybody. They had to remove inmates to do testing and all that stuff from it. I don't see where there is no hypothetical threat to the penal institution. It was a threat by them having the meth brought into the jail.
All right, thank you. Well, once again, in the same case that the court referenced earlier, which is People versus Dickinson, the 321 Mich. App. Page 1, 2017, is actually directly on point. The same objection was raised there, and the Court of Appeals determined that the trial court properly scored it at 25 points, noting that the introduction and delivery of a controlled substance in a confinement facility such as a jail or prison does threaten the security of guards, the health of the other people that are there, and I mean the defendants, post, pre-trial, other employees that are working at the jail. So again, the court rests on that decision, People versus Dickinson, and denies that challenge to OB 19. Thank you. Next, Mr. Johnson.
For the record, same challenge to possessing contraband, same argument.
Then I understand that argument. I think it's a good argument to raise to preserve how we're based upon the same case law referenced by the court a moment ago. The court denies that challenge for offense variable 19 on that fourth count. Thank you. Any other corrections or amendments, Mr. Johnson, anywhere else in that particular PSI?
No, sir, Your Honor.
Thank you. Mr. Ringstrom.
Yes, Your Honor. There's 3 different types of punishment, as this court is aware of. One were for rehabilitation. When this court goes through this criminal history, which I know this court does, I believe the court will see that there is no rehabilitation for Molly White at this point in time. In fact, she seems to think that she's above the law, and most of the times with the criminal history as is. But the second one would be protection of society as a whole, which, again, going through her criminal history, you'll see that she does have an awful lot of thefts and drug crimes. She is a drug dealer. I believe that the court sat through both of the trials, heard the testimony of Tiffany Jacobson, which I think supports the fact that she's a drug dealer. And certainly these charges, as stated, shows that she is a drug dealer. So I do believe the society needs protection from her. The biggest one is deterrence. So many times when we have drug cases and things like that, unfortunately, guidelines would say, oh, maybe just rehab, maybe a slap on the wrist, maybe a little bit of prison time. In this particular case, we're dealing with high guidelines. And I think that for deterrence purposes, she does need to be able to go away for a long time also. I think that we need to be able to set an example that if you mess with drugs, if you mess with our jail system, this is what could happen to you at this point. The guidelines are the way they are. Recommendations for 15 years. I think that Molly White has deserved at least the 15 years, if not more. And because these crimes did happen in a jail, I think that the court should consider consecutive sentencing as well.
Thank you. One moment. All right, Mr. Johnson, allocution, sir.
My client deserves to go to prison. We don't concede that. I mean, we concede that, we don't argue that. The issue here is what is a fair punishment? And the prosecution, the first statement about Ms. White is that she's a drug dealer. So was I. I sat on a college campus with a marijuana joint before marijuana was legal, smoked it, and passed it to somebody else. I delivered marijuana. That was a crime. That was delivery. I didn't make any money from that transaction. And I think courts should make a distinction between for-profit dealers that traffic narcotics into a community and make their living selling narcotics to particular people, and users who trade in narcotics for other narcotics supplies, or in this case clean urine. Miss White did not make any money from this transaction here, but she did engage in what I will admit is one of the cardinal sins in the criminal justice system. She committed a crime while she was in jail, trying to resolve accusations of another crime. And, that is disrespectful to the court, it's disrespectful to the law, and it thumbs just at authority. But the court heard the testimony. A lot of people think that she was high, or thought that she was high or under the influence when she engaged in that behavior. Miss White sits here, today, with forced sobriety, and realizes how she has sacrificed a good part of her life to drug use, and is going to sacrifice some other good part of time in her life away from her children because of her drug use. I cannot sit here and justify anybody having 15 felony convictions. I'm not even going to get into the misdemeanors. But she's going to jail, y'all. She's going to prison. We understand. But for her level of involvement, the small amount of methamphetamine that we're talking about, I couldn't even do the math. Assuming that the prosecutor's theory was right, and she snuck an 8-ball, 3.5, ounces into, 3.5 grams into the jail. I couldn't even do the math on how many days she's going to get there's too many numbers behind the decimal point to do the math per number. So for an individual who is not a for-profit dealer, for an individual who wasn't maintaining a dangerous meth house that was emitting gas into the environment, that had a fire risk, for an individual who may have been high and suffering from the effects of narcotics dependency at the time she committed the crime, I'd ask the court to sentence her to 9 years in the Michigan Department of Corrections. That is almost a decade. That is what you would see for violent offenders. That, I believe, takes into consideration the harm she did to herself, the harm she caused or could have caused to other people had that methamphetamine been laced with fentanyl. It takes into account, the numerous felony convictions she's had. It takes into account the fact that she did this while in custody, Your Honor. I think that's fair, Your Honor. Had she been, like some of my other clients, maybe downstate, and she had a pocket full of money, and there was a search warrant, and there was a big, local task force investigation, maybe we'd be having a different conversation, Your Honor. But I think 9 years is fair. And we'd ask for a concurrent sentence on all charges, and we'd ask for 12 months on the first file, Your Honor, the possession file, and close that file out.
Thank you. Ms. White, if you wish to say it, now's the time.
I know that I've been standing in front of you for a long time in my life, and I can't justify that. I am an addict, and I understand that, and I do need help. I understand people don't think that I'm the person that they think that I am. I've made mistakes, and I own up to them. I don't try to take other people down with me. That's my own life, and I don't even have excuses for that. The only thing I can ask is for I don't even know how to say it, a chance to come out of here. And I understand prison's going to happen. Understood. Like, I'm still a mom and I still have custody of my daughter, yes. And I know that I can't change anything. However, I can only ask for, even doing a prison sentence, that I still understand and I get help while I'm in there as well.
All right. Thank you, Ms. White. Mr. Blazek, I just found a small typo on CFJ 284, page 22. Under,
I'm sorry.
I'm sorry. Oh, let's see, 4, but it's going to apply to both. There's just a wrong date on the narrative for entry 26 of 31. It says that she tested positive for meth 2 years from now. So it's just a small typo. I'm surprised I caught that one, but I just saw it and I'm like, you'll see that it says April 26, 2028.
I see it.
Yeah. So again, I like to think maybe quantum mechanics will discover wormholes and time travel, but right now, as far as I can tell, they have not. I watch a lot of Star Talk, so I'm pretty sure it hasn't yet happened. But anyways, all right. So I start off there with a slight like note, intentional. Controlled substances such as methamphetamine get a hold of people and they make good people do dumb stuff. And we all tend to make bad choices. And when we do, we analyze them from our own selfish perspectives and justify sometimes such actions and normalize it so we continue to do it. And in here, it's been Miss White's challenge. Methamphetamine has been a problem with her challenge. The challenge for her. I don't like saying problem because it's the challenge. I don't like a problem sounds like it can't be fixed, maybe. A challenge gives you the opportunity of fixing it. And that's what I want. I want this to be positive. I often will call you by your first name, not to be rude. And it's not merely to highlight that I see it often, but Molly, you keep struggling here, and I'm really sorry to see that. I want to see everybody succeed. Now, you have a long criminal history. You've had 31 adult entries, and I know there's some dismissal, so clearly I don't take any dismissal into consideration. But you are a young person. You're under 40. Between 35 and 40. I'm not supposed to say a woman's age in public, so I'm just going to give you a range. Mr. Blazek, we probably need to make a note in file 3614 that there was a change of attorney. Even though Mr. Dick represented her at the trial, Mr. Johnson obviously stepped in and helped and represented her on the sentencing portion of that file. So I think it's worth making that note. Thank you. All right. The next thing we're going to do, Mr. Blazak, is on CFA 145 for both of these. You see where it says methamphetamine? We're going to put an end date there. Okay. That end date is going to be the date she was arrested. Okay. I think it's a good idea to have an end date. To know that's the day Molly White changed into the new Molly White 2.0.
In 14 months today.
Good. Good. All right. So in addition to the defendant's prior criminal history, I also have to highlight because I have to do this. And sometimes it sounds like I'm being negative, but the legislature and the Supreme Court tell me I have to, which is fine because I need to justify the sentence. So Molly has a relatively long criminal history, and it involves a lot of crimes of dishonesty like theft and retail fraud, which is why I say drugs are not victimless crimes, because wherever I see a drug case, there's almost always a retail fraud series of cases too, or theft cases. In addition to that, we see other things that are, I call them crimes of dishonesty, like operating without a license or driving while a license is suspended. And of course, larceny in the building, attempting to receive and conceal stolen property. So we have issues with deceptions, but we also have issues with prior deliveries of controlled substances. Back in 2012, there were a couple cases. And I also recall that in the testimony in file 3614, that there were 4 people in the car, and there was testimony that Ms. White was on the phone and needed to go someplace to either pick up or to deliver methamphetamine. Now, she didn't do it. I'm not sentencing her for that, but that's where the people have some, legitimacy of saying she's a drug dealer, just even in that file alone. And this is where she was the driver, and she was passing it around to people in the vehicle, and that put other people at risk because she was using as well. That's the problem of controlled substances. So it put other people at risk. In that particular file, the court recognizes its discretion to sentence the defendant as a 4th habitual felony that includes an increased potential sentence of up to life. The court's not going to sentence her up to life, but I can pick a term of years.
Which file are you going, Judge?
File 3614. So the court assesses a $68 state minimum fee, $130 crime victims' right fund fee as required. In that particular case, the court exercises its discretion to sentence the defendant as a 4th habitual felony offender. And in that case, the court sentences the defendant to a period of prison term of 36 to 240 months.
So I get rid of the second offense notice.
What's that?
Do I get rid of the second offense?
Well,
Is it-
yes. Yeah. Thank you. The court has the discretion to pick either one. And so I'm just going to pick the habitual felony 4th. It's the same thing as a second or subsequent in effect. All right. And in that file, the defendant receives jail credit, and that one should have been 219 days of jail credit. Now we turn to the next file, 3689. Again, the court assesses a $68 state minimum fee for each of the felonies, so it's 4 of those, and a $130 crime victims' right fund fee. The court is not going to assess any other fines or costs. The court is also going to exercise its discretion and disregard. It's still discretionary. It's not mandatory consecutive sentencing because it's not a quote unquote major controlled substance, because it's not a narcotic or cocaine. It's an optional. So the court is not required to sentence the defendant consecutively, and therefore I exercise that discretion and not sentence her consecutively. And these sentences will run all concurrent, not only with each other, but also file 3614. All right. In that file, as to count 1, tampering with evidence. Again, the court exercises its discretion to sentence the defendant as a 4th habitual felony offender, which increases the potential maximum up to 180 months. Therefore, the court sentences the defendant to that count to 24 to 180 months. And the defendant receives 239 days of credit in that file. As to count 2, this is the assault, resist, obstruct a police officer. Again, exercising the discretion to sentence the defendant as a 4th habitual felony offender. The court sentences the defendant to 24 to 180 months, again with 239 days of credit. Now, I'm going to go back, and I had a note, and I did it wrong because I too am not great at math. In file 3614, the cap is actually, I'm going to reduce it from 240 to 180. But what I've done is in effect, I still exercise the 4th hand, but I'm putting the cap down the same that I did for those last 2 counts. All right, so now I'm back to file 3619. So now we get to, and I'm going to jump and get to the count 4. The count 4 is bringing the contraband into a jail or prison. Here, the court is also concerned with, again, I used to work at a prison. I began my legal career at the United States Disciplinary Barracks for the Department of Defense, and I know how different and restrictive and pressurizing life is inside of a jail. Pack of gum, a soda can be worth hundreds of dollars. So when you're looking at controlled substances here, this wasn't merely bringing it in. It was, she could have just flushed it down the toilet, but she didn't. Well, at least initially. All right, so the court here sentenced the defendant to 224 to 180 months with 239 days of credit. That is, so far, every sentence I've issued is within the guidelines. And they will also be within the guidelines here for count 3. Count 3 is the delivery of methamphetamine. Again, while she may have been, in effect, passing it around, she could have just flushed it. And in each case, she was delivering it by giving it to people. And that's a crime. And it's quite clear that she is dealing methamphetamine. So here, the court sentences the defendant as follows. The court sentences the defendant to a prison term of, one moment, I got to do the math to get the top end. 1 second. $180 to 240 months. 239 days of credit. These all run concurrent once again with each other and with the 2 files. The court elects not again to sentence consecutively. All right, have I missed anything, Mr. Blazak?
I don't believe so, Your Honor. Thank you.
Mr. Riekstrom?
I don't believe so.
And Mr. Johnston?
Yes, Your Honor, we believe that the jail credit on the 3614 case should also be 239 days.
Let's take a look here. She was from May to October of last year, Mr. Blazak. Was she serving a sentence on something?
Yes, she was.
All right.
Okay,
So that, I think that she had a probation violation. Is that right?
Yeah, I had 147 days that I wasn't getting credit for, and then the 239.
Yeah, that's a good point to raise, but she was serving sentence on a PV. All right, thank you. One moment. Ms. White, Mr. Johnson's going to bring to you for each file 2 copies of one document. Each of these documents for each of these 2 files tell you that you have the right to file an claim a right to appeal if you had trials and were convicted by jury trials. You're going to place your initials on the first copy for each file. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the other copy. Now, this document tells you that you have the right to appeal again the convictions and sentences in both of these cases. And if you choose to file a claim of right to appeal, you may fill out the bottom half and request the appointment of an appellate counsel. You must return it within 42 days. Find that the sentences again are reasonable, proportional based upon the prior criminal history, bond violations, and other parole violations, and all the other factors considered and contained inside the pre-sentence investigation report. Also recognizing the court did not exercise consecutive sentencing. Thank you. The court has received those back from Mr. Johnson, and I see Ms. White probably filling out the forms right now, which I don't blame her. That happens all the time. Anything else, Mr. Blazing?
No, thanks, Your Honor.
Mr. Rinkstrom?
No, Your Honor.
And Mr. Johnson?
no, Your Honor, thank you.
Molly, I do really sincerely wish you good luck. You're always nice generally here in the court. Again, good people make bad decisions, and when it involves controlled substances, it's really hard. All right, thank you. We're adjourned.